Okay, thank you everyone for joining. We're going to get started now. The topic of our webinar today is problematic promotional activities, what SME issuers need to know. My name is Julie Frez. I'm an accountant in the corporate finance branch of the Ontario Securities Commission, and I'm the coordinator for the OSC SME Institute this season. I'm delighted to introduce our speakers for today's webinar. Jonathan Blackwell and Katie DiBartolo are both senior accountants in our corporate finance branch, and Samreen Beg is a senior legal counsel in our corporate finance branch. Some housekeeping items before we begin. This session is being recorded and the recording will be available on the OSC's YouTube channel following today's presentation. A copy of the slides is available as a handout through GoToWebinar, so you should be able to download the PDF from the side panel. You can submit questions throughout the presentation using the chat feature, and we will be answering them at the end of the webinar. If for any reason we cannot get to your question, we'll reach out to you after the session. You will receive an email with a survey after the session, and we would appreciate your feedback. And lastly, at the end of the session, you will be able to screenshot proof of attendance for CPD requirements, so just look out for that. Before we begin, I'd like to remind participants that the views expressed in this presentation are the views of the corporate finance staff and do not necessarily represent the views of the Commission. The presentation is provided for general information purposes only and does not constitute legal, accounting, or technical advice. Information has been summarized and paraphrased for presentation purposes, and the examples have been provided for illustration purposes only. Responsibility for making sufficient and appropriate disclosure and complying with applicable securities laws remains with the company. Information in this presentation reflects securities laws and other relevant standards that are in effect as of the date of this presentation. The contents of this presentation should not be modified without express written permission of the presenters. This document should not be distributed externally. For any of our attendees who may be new to the OSC SME Institute, a little bit of background. The objective of the OSC SME Institute is to support small and medium-sized businesses in facilitating cost-effective compliance through issuer outreach and education. It is important for issuers to know securities regulatory requirements, and we're here to help them navigate regulatory waters. The idea is that if we can help issuers to better understand and comply with their disclosure requirements, they can focus their resources on building their company. Ultimately, we both have the same goal: for issuers to provide appropriate and meaningful information to investors to assist them in making informed investment decisions and to stay onside regulatory requirements. It is important to remember that at the end of the day, the investor confidence in the information that companies provide is critical to the success of the company. Before we get into the topics for today, I wanted to take a moment to remind everyone of the topics we've covered in recent SME webinars. Each of the sessions listed on this slide has been recorded and posted on the OSC YouTube channel. The Continuous Disclosure webinar reviews and discusses deficiencies commonly noted by staff in continuous disclosure filings pursuant to reporting issuers' disclosure requirements and provides guidance to assist issuers in reporting obligations. And that includes National Instrument 51102 continuous disclosure obligations and National Instrument 52112 non-GAAP and other financial measures disclosure. The prospectus webinar provides a general overview of the prospectus regime and reviews certain prospectus exemptions available to SMEs to help facilitate capital raising. The webinar also discusses common issues identified in prospectus reviews, including concerns regarding a reporting issuer's financial condition. Finally, the CEDAR Plus webinar recorded earlier this year provides some practical tips and insights on navigating CEDAR Plus filings effectively, including profile and fee management, continuous disclosure challenges, prospectus filings, exempt market filings, and application filings. For today's SME webinar, our primary focus is to review and discuss deficiencies commonly noted by staff in continuous disclosure filings and to outline staff's expectations regarding the applicable securities laws when engaging in promotional activities. The goal is to ensure that investors are receiving high-quality disclosure to assist them in making informed investment decisions and avoid overly promotional disclosures being used as a tool in market manipulation. The first section of our presentation will set the groundwork for understanding promotional activities, including overly promotional and unbalanced disclosures with reference to CSA Staff Notice 51356, problematic promotional activities by issuers, use of social media and press releases, and updates to previously disclosed forward-looking information, including guidance and best practices for MD&A disclosures. The second half of our presentation will dive into other promotional disclosures with respect to greenwashing, including some background on climate-related disclosures and recent developments. For clarification, we want to acknowledge that these topics are not all inherently promotional in nature. We'll go over several examples where staff have identified the disclosure as being unbalanced or overly promotional and how the disclosure might be presented more appropriately. Now I'll turn it over to Jonathan to take us through the first few sections of today's presentation.
Okay, thank you, Julie. We're focusing on problematic promotional disclosure today because this is a frequent and potentially serious issue for small and medium-sized issuers that we often see, and it's one that undermines the integrity of capital markets and puts investors at risk of harm from making misinformed investment decisions. Growth and development-oriented businesses are often inherently more focused on their operations and growth and less focused on building good governance structures as a result of the early stage resource constraints. And in today's environment, we're all engaging in competitive marketing to get our key messages and ideas out in front of the eyes of those in our target markets. But public companies need to pay special attention to how they're doing this. It's easy to cross the line between balanced, optimistic assessments of operations and problematic, overly promotional or unsubstantiated claims, which can lead to prosecution or other regulatory outcomes. In 2018, so we did publish, as Julie said, CSA Staff Notice 51-356, which aims to provide issuers with specific examples of the kind of problematic and overly promotional disclosures that we often see. The scope of that review included looking at issuer news releases, websites, and social media feeds. That staff notice is a good resource, and we encourage issuers to refer to it. National Policy 51-201 also reinforces aspects of the Securities Act by discussing certain disclosure guidelines which are relevant to the topic of overly promotional disclosure. So first, avoiding misleading or untrue statements, relying on factual and supportable statements, disclosing bad news just as promptly and completely as good news, disclosing sufficient detail for investors to understand the substance of what's being announced, avoiding exaggerated or hyperbolic language, and ensuring balanced disclosure, which often will include statements about the barriers, time, and costs involved in achieving any positive events being announced. So this slide lists various sources of CSA and OSC staff guidance that you may wish to refer to regarding misleading, unbalanced, or overly promotional disclosure, including the staff notice and national policy that were mentioned on the last two slides. To build on these principles, we'll use the next couple of slides to provide a few more illustrations about what problematic promotional disclosure could look like and how it can be improved. Okay, so in this first example, we have a pre-revenue issuer talking about achieving $20 million of revenue at some point over the next 5 years. In the absence of other information, we may view this as unbalanced because the statement talks about the revenue upside of the business, which is markedly different from the history of the business, given that the business is currently pre-revenue. And also the sample disclosure here does not talk about related barriers, including time and cost needed to achieve that $20 million in eventual revenue. Additionally, for a pre-revenue business with significant work to do before getting to revenue, there may not be a reasonable and supportable basis to forecast for a time period that's 5 years away beyond speculation. Statements should be supported by objective data that provides an issuer with a reasonable basis to make those statements. If there were a reasonable basis for this forecast, then the issuer would at minimum have to discuss the assumptions supporting the forecast that's been provided. Okay, so this slide has enhanced disclosure for that same example, and the enhanced disclosure on this slide addresses the concerns that I spoke about by talking about the time, cost, and nature of work that are required in order to begin generating revenue for this company, and that is more balanced. The enhanced disclosure also removes mention of a $20 million revenue forecast target because in this enhanced disclosure, it becomes more clear that sales are only expected to start 4 to 5 years from now after this product is commercialized. And that time span of 4 or 5 years away is too long range to have a reasonable basis or to be supported by specific facts for this pre-revenue issuer that has a lot of steps to get to commercialization yet to go. Okay, so on this slide, we have a second example. So this one is of a company disclosing that it is entering a new and prominent industry, in this case, the crypto industry, where it will be launching a crypto trading platform. I would note that we've seen several examples of this kind of misleading, unbalanced disclosure in the past when trendy new industries emerge, with some looking to capitalize on the excitement of being associated with a new industry. The disclosure in this example lacks background and context, which is needed to fully understand the announcement that's being made and for the announcement to be balanced and not misleading. So this slide presents sample enhanced disclosure for that same example, and it responds to that concern by acknowledging that this change of business is at such an early stage that it's not possible to estimate the time and costs that would be needed to develop a crypto exchange for this issuer. And it also acknowledges that nothing's been done to date to develop any crypto-related business or assets for this issuer. That results in a fuller picture of what the announcement actually means by talking about what has been done and what remains to be done to implement the change that's being announced. Okay, here's a third example now where a company is announcing an acquisition. In this disclosure, it's not clear what, if anything, the acquisition is contingent on, how certain it is to occur, or why it represents, as noted in the disclosure, a $500 million opportunity for which the company believes it would be immediately accretive. In general, the disclosure here on this slide is insufficient to understand the transaction that's being announced. On this slide, we have enhanced disclosure for that same example, and this clarifies that the announcement of the acquisition is based on a non-binding letter of intent, which remains subject to the due diligence of both parties. It also confirms that the immediately accretive statement about the acquisition is dependent on the acquiree opening its first store in November of this year. It also confirms that the expected $500 million opportunity to the company that was initially disclosed on the last slide is actually referring to the size of the industry that the acquiree operates in, and not to the revenue or revenue potential of the acquiree target specifically. And that's a very important distinction for balanced disclosure to have. Okay, so this is a fourth and final example, and this is a statement of sample disclosure that is unbalanced because it contains hyperbolic language, which is unsupported by specific facts. So the example here indicates that the company is developing a COVID cure style breakthrough, which will be the play of the decade for early stage investors, end quote. So we've seen examples of these kind of statements more commonly in investor presentations or other materials posted on an issuer's website, as opposed to SEDAR+ filings. But that doesn't make the misleading statement any less problematic. Rather, public companies that issue misleading news releases regarding the status of their products, particularly in emerging sectors like COVID-19 related health technologies, in doing that, they deprive investors of the ability to make informed investment decisions. It's vital that investors receive complete, factual, and balanced information, especially in emerging sectors. Public companies in these sectors that overemphasize the market readiness of their products while omitting the challenges of launching to market may mislead investors. The enhanced disclosure on this slide removes the exaggerated or hyperbolic language and replaces it with information about the time and cost needed to develop the product, which provides needed balance in connection with positive claims about the product's potential. Okay, so this slide lists a few more examples of what promotional or unbalanced disclosure could look like. These are things that we often see again, such as, but not limited to, bad news buried at the end of a positively headlined press release, or frequent announcements of positive events like potential acquisitions without subsequent announcements to confirm when and if those events failed to transpire, like an earlier announced acquisition opportunity that fell through, for example. Okay, so another venue where we've seen overly promotional disclosure is on social media, including company websites and other online web pages that are distinct from traditional CDAR Plus filings. Reporting issuers must constantly be aware of the securities reporting obligations that their social media activities may trigger, even if their social media posts were intended to communicate with other groups like customers instead of investors. Given that investment decisions are made on material information, it's critical for issuers to adhere to high-quality disclosure practices, regardless of the venue used for dissemination of that disclosure. In 2017, we published CSA Staff Notice 51348 in order to talk about, amongst other things, specific examples of unbalanced disclosure that we've seen on social media. Overall, companies need to be mindful that social media disclosure may often consist of very brief snippets of text. And while there's nothing wrong with disclosing positive news, issuers still need to be equally mindful of whether that disclosure is balanced, regardless of whether it's on CDAR Plus or on social media. So during our social media disclosure reviews in the lead up to the staff notice that I just mentioned, we saw instances where the disclosure provided was either untrue or promotional to such an extent that it could have misled investors. In several instances, issuers provided commentary or other information about their financial results on social media, which did not appear to be consistent with or contained in their continuous disclosure documents on CDAR Plus, like their financials or MD&A. In some cases, the social media disclosure could have been out of date or just plain inconsistent with information on CDAR Plus filings. A particularly common issue is where issuers disclose a measure of performance that's not mentioned in CDAR Plus filings, like the MD&A. So for example, an issuer may say something like, core earnings improved by 20% this quarter. If CDAR Plus filings like the MD&A don't discuss the concept of core earnings, then the issuer has effectively, in this example, created a non-GAAP measure in their social media disclosure. And that measure would have been selectively disclosed then because it's not generally available to all investors through regulatory filings or a press release. It's just on social media. Additionally, in these cases where a non-GAAP measure like core earnings was created exclusively for mention on social media, or was accidentally only mentioned on social media, the typical non-GAAP measure disclosures that we would normally see in MD&A, such as, but not limited to, a quantitative reconciliation to the nearest GAAP measure, were missing. And that's a significant issue that's strongly indicative of misleading disclosure. Another disclosure issue we've seen on social media relates to analyst reports that are paid for by the issuer. In these cases, issuers have paid a third party to write a positive report about the issuer, and that report may or may not appear to be in the format of an arm's length analyst report. These reports may have a footnote disclosing at the end that the report was paid for by the issuer, and therefore that the report is not independent or arm's length. As a result, these reports may be more akin to advertisements that are disguised as independent analysis. They may also provide highly optimistic stock price or revenue targets or other forward-looking information. And if issuers post these reports themselves, then they should be prepared to take responsibility for the forward-looking information in them, including by updating it when and if any forward-looking targets appear unlikely to be met, and also by complying with other disclosure requirements around forward-looking information, notwithstanding that the target was provided not directly by the issuer, but in a paid-for report that the issuer itself then posted. Of utmost importance, though, as noted in CSA Staff Notice 51-348, which was our social media review, we expect that the non-independent nature of these reports and the fact that the issuer paid for them is prominently disclosed in the report, which would certainly require more than footnote disclosure on the last page alone. Okay, on a related note, OSC staff recently provided some tips in our Corporate Finance Branch 2022 annual report related to disclosure best practices for press releases. We've included them here on this slide for future reference for you. I also want to speak briefly and more specifically about forward-looking information, which is a topic that's often connected with promotional and unbalanced disclosure. National Instrument 51-102 defines forward-looking information, or FLI, as any disclosure about possible events, conditions, or financial performance that's based on assumptions about future economic conditions and courses of action. That could include KPIs, efficiency or production targets, pricing or cost projections, or other things. FLI generally includes two subcategories dealing with financial information. Those are on this slide here. And they are FOFI, or future-oriented financial information, and the second one is financial outlooks. FOFI, or future-oriented financial information, is presented in the format of a historical financial statement, but now it's future-oriented. Where we typically see that is in a prospectus or a rights offering. Financial outlooks, on the other hand, are not in a financial statement format. They often include examples like projected EBITDA or expected revenue or profit in a future period, or forecasted R&D spending, for example. While FOFI and financial outlooks are two subsets of FLI, FLI also includes non-financial measures like estimates of the timing for the number of stores that may be opened by a retail issuer, for example, and again, timing when that may occur. This slide identifies where in National Instrument 51-102 the forward-looking information disclosure requirements come from. And this slide also paraphrases those requirements. So, for example, when initially providing forward-looking information, issuers need to back it up with the material factors and assumptions that are involved in making the forward-looking statement. So that could be what needs to happen in order for the forward-looking target to materialize. And then in periods subsequent to when the forward-looking target was initially disclosed, issuers need to think about updating the forward-looking information when events and circumstances indicate that the target may not be met. This includes explaining changes and the reasons for them. Overall, forward-looking statements may be misleading when they're unreasonably optimistic or aggressive, when they lack objectivity or are not adequately explained. It's also important to note that these disclosure requirements apply regardless of which document the forward-looking information appears in, not limited to any documents filed on SEDAR+, like MD&A, AIFs, or news releases, but also to website content and marketing materials, for example. Okay, so this slide starts giving an example of sample disclosure to illustrate the point. So this slide has an example of an issuer with a rapidly growing retail store count. And in this MD&A excerpt, the issuer is providing historical background about its recent store growth. And in this slide, the issuer adds on forward-looking statements about significant expected growth in revenue and the number of store locations over the next 3 years, which we would, in this case, view as deficient because it doesn't provide any material factors and assumptions to support the forward-looking statements. And it's also potentially misleading because there doesn't appear to be a reasonable basis for forecasting what in this example appears to be unprecedented growth from the 36 retail stores that are open now to 400 open stores down in 2026. If that kind of substantial growth is not supported by history or by any contracts or proportionate progress to date, then as a result, the long-range nature of the forward-looking statement makes it appear speculative. This slide provides improved sample disclosure. And first off, you can see that the financial outlook has been, in this enhanced disclosure, limited to a period of 1 fiscal year for which the information in the outlook can be reasonably estimated. Given the lack of history supporting planned future growth and the lack of crystallized events which would support a more long-range forecast, and secondly, the assumptions supporting the outlook are clearly disclosed and appear to be reasonable given the issuer's limited operating history. I won't elaborate on this slide, but this is trying to give an example of how the forward-looking statements that we saw on the last slide could be appropriately updated as required in subsequent reporting periods. As I mentioned earlier, forward-looking statements must be updated in subsequent reporting, and you should refer to the requirements of Section 5.8 of National Instrument 51102 on that. And lastly, this slide provides an example of how an issuer may decide to withdraw forward-looking statements when and if it later becomes clear that they're not going to achieve the forward-looking targets. Of course, it's the issuer's decision whether to withdraw or update the forward-looking targets, but in either case, a discussion of the reasons that the original target won't be met is required. And finally, we wanted to emphasize potential regulatory responses related to the kind of problematic promotional activities that are cited in CSA Staff Notice 51356, including requiring an issuer to issue clarifying news releases or to refile continuous disclosure documents. And in egregious cases, OSC enforcement action may be warranted. Where corrective disclosures made by an issuer arising from an OSC review, an issuer's name will be placed on the OSC's public list of refilings and errors for a period of 3 years. Okay, thank you. And I'll now pass the presentation to Samreen and Katie, who are going to begin discussing climate-related disclosures.
Thanks, Jonathan. So in this next section of the webinar, we'll be discussing greenwashing and issues that you should consider in your continuous disclosure documents going forward. The use of disclosures pertaining to ESG or sustainability factors has grown rapidly in recent years as companies look to be more transparent on how they can manage ESG factors and related risks. We have observed an increase in issuers making misleading, unsubstantiated, or otherwise incomplete claims about business operations or the sustainability of a product or service being offered, conveying a false impression. This is commonly referred to as greenwashing. As we stated in CSA Staff Notice 51364, Continuous Disclosure Review Program Activities for the fiscal years ended March 31st, 2022 and March 31st, 2021, the terms ESG or sustainability are used to refer to a wide variety of factors. For example, climate risks, pollution and waste management, biodiversity, carbon and other greenhouse gas emissions, energy efficiency, and diversity and inclusion, among other factors. The breadth of what is encompassed by the terms can make using the terms misleading if there is not more specific disclosure about the particular factors being considered and how they're being measured and evaluated. We've discussed greenwashing recently in the OSC Corporate Finance Branch Report from 2023, noted on the slide, as well as CSA Staff Notice 51364, which I mentioned earlier. When thinking about greenwashing, it's important to keep existing CSA guidance and requirements in mind. The key areas are overly promotional disclosure, which is discussed in CSA Staff Notice 51356, Problematic Promotional Activities by Issuers. This notice discusses concerns with disclosure and promotional campaigns that provide unbalanced and/or unsubstantiated material claims about the issuer's business. Misleading statements, which are discussed in National Policy 51201, specifically the general prohibitions against false or misleading statements that would be expected to have a significant effect on the price or value of an issuer's securities. Finally, requirements on forward-looking information, which can be found in Parts 4A and 4B, and Section 5.8 of National Instrument 51-102 Continuous Disclosure Obligations specifically addresses disclosure of material factors and assumptions and updates to previously issued FLI. We have identified greenwashing in CD documents, continuous disclosure documents, as well as voluntary documents such as sustainability or ESG reports and public surveys. When describing current and proposed ESG-related activities, issuers should avoid misleading promotional language. With increased access to data and information online, it's important to ensure that all public disclosures, whether voluntary or factual, are balanced. An issuer's disclosure should be specific and should be accompanied by supporting data, reports, or other factual disclosure as applicable. As an example, an issuer's disclosure of a target to transition to net zero can be misleading if the issuer has no credible plan to achieve such a target. The next three examples we will be reviewing were included in CSA Staff Notice 51364, which we referred to earlier. The first of these examples is a statement made in 2022 that the company plans to be carbon neutral by 2023. The first issue with this statement, the issuer made an unsubstantiated claim stating that it would be carbon neutral in the very near term. Unless the statement can be supported by facts and corporate activities, it's misleading and promotional to include. The second issue is that this type of statement would have typically constituted FLI. The issuer must have a reasonable basis for the FLI, identify the material risk factors that could cause actual results to differ materially, state the material factors or assumptions used to develop the FLI, and describe its policies for updating the information. The second example from CSA Staff Notice 51364 is a statement saying strategic relationship with high-quality partners attentive to environmental stewardship and performance enhance our long-term value. Our key partner exemplifies this by setting aggressive emissions reduction targets and investing in multiple environmental economic enhancing technologies. The key issue with this statement is that the issuer is providing promotional language with respect to its partnership, specifically the partner's emission reduction target and investing in environmental technologies, but has also provided no accompanying disclosures to support these claims, including that the partner is high quality. The third example from CSA Staff Notice 51364 is a statement that the company is a global leader in environmental solutions. The key issue with this statement is that the issuer is providing promotional language with respect to being a global leader in environmental solutions without any evidence. In addition, in this case, the issuer had only generated nominal revenue from its operating activities, which was not consistent with the promotional language in the statement. Taking all of this into consideration, we wanted to highlight the following. Where an issuer discloses future plans to improve its operational performance in the context of ESG standards, such as to reduce greenhouse gas emissions or to obtain a carbon neutral position, we want to remind issuers that this type of statement will typically constitute FLI. An issuer must have a reasonable basis for FLI. Again, identify the material risk factors that could cause actual results to differ materially, state the material factors or assumptions used to develop the FLI, and describe its policies for updating that information. So we wanted to briefly touch on another important greenwashing example, which we discussed in our most recent corporate finance branch report from 2023. Where an issuer is using a rating to demonstrate its ESG impact, issuers must also be careful to not include promotional or misleading language. For example, on the slide, we have language stating that the issuer obtained a high score on a national corporate governance survey without disclosing the actual score, the parameters on which the survey was based, the name of the third party conducting the survey, and the date of the survey. As a result, where an issuer is using a rating to demonstrate its ESG impact, the following should be disclosed: the actual rating, a description of the specific set of criteria on which the rating is based, the identity of the third party certifying the rating, and the date of the rating. So this concludes our discussion of greenwashing and overly promotional disclosures. However, in light of the discussion on greenwashing, we thought it would be helpful to give some background on existing climate disclosure requirements. The following discussion is intended to highlight the kinds of climate-related disclosure that we currently expect to see in an issuer's continuous disclosure filing. So, as you may know, materiality is the determining factor for any assessment of whether information is required to be disclosed in an issuer's continuous disclosure documents. As provided in Forms 51102F1 relating to MD&A and 51102F2 relating to an AIF, information is likely material where a reasonable investor's decision whether or not to buy, sell, or hold securities in an issuer would likely be influenced or changed if the information was omitted or misstated. In the context of climate change, this assessment can be challenging because it's an evolving area occurring over a longer time horizon and may be difficult to quantify. In some cases, materiality may be interpreted narrowly, with issuers concluding that they don't have any material risks. However, many companies, including those in non-carbon intensive industries, are or will be exposed to climate-related impacts. Through staff notices, we've encouraged issuers to undertake analysis of climate-related risks and adjust their approach to time horizon, specifically that materiality assessments should not be limited to the short term, and measurement, meaning that issuers should not only consider the existence of climate-related risks, but also quantify and disclose the potential financial impact where it's practical to do so. It's the issuer's responsibility for making materiality assessments, and what's material to an issuer will depend on the circumstances. Issuers shouldn't rely solely on a monetary threshold, however, to determine materiality, since some climate-related matters may not be quantifiable at this time, but may nonetheless be material. On this slide, we have our current disclosure requirements that would cover climate-related disclosure. Form 51102F1 contains a requirement that an issuer discuss in its MD&A its analysis of its operations for the most recently completed financial year, including commitments, events, risks, or uncertainties that it reasonably believes will materially affect its future performance. Form 51102F2 contains the requirement that an issuer disclose in its AIF risk factors relating to it and its business that would be most likely to influence an investor's decision to purchase the issuer's securities. The form also requires an issuer to disclose the financial and operational effects of environmental protection requirements in the current financial year and the expected effect in future years, and also describe any social or environmental policies that are fundamental to the issuer's operations, such as policies regarding the issuer's relationship with the environment and the steps the issuer has taken to implement them. Issuers may choose to include certain forward-looking information in their continuous disclosure, but they must comply with the FLI requirements if doing so. FLI requirements do not relieve issuers from disclosing material climate-related risks, even if these risks are expected to occur over a longer time frame.
So to reinforce the message that there are existing requirements and to assist issuers in meeting their disclosure obligations, the CSA has issued 3 publications. So first, in 2010, we issued CSA Staff Notice 51333, which provided guidance to public companies on existing continuous disclosure requirements relating to environmental matters generally. Then, in 2018 and 2019, we issued 2 publications that focused on climate change specifically. So first, in April of 2018, we published CSA Staff Notice 51354, which reported on our research and other work in this space that was conducted in 2017. So in particular, that work consisted of a review of public disclosures, an online survey on current practices and challenges, and in-person consultations with public companies, institutional investors, advisors, and other users of disclosure. So then in August of 2019, we issued CSA Staff Notice 51358. So this staff notice was also the result of our 2017 work, where we saw some companies have difficulty with assessing materiality of climate-related risks, given the uncertainties relating to their timing and impact. CSA Staff Notice 51358 sets out guidance for public companies, particularly smaller ones, to assist them in preparing disclosures related to climate change. So we aim to do 3 things in this guidance to help public companies manage making these disclosures. First, the guidance set out examples of climate-related risks that may affect companies and the related financial impacts. Second, it provided support to boards and management by asking practical questions for them to consider. And this included questions along the line of whether the board is getting the right information to understand climate-related risks that their business is facing. Do they have the right expertise at the board and executive level? Are they aware of their investor base and whether they are factoring in climate-related issues into their investment and voting decisions? And whether the issuer's regulatory filings contain the required disclosures in respect of material climate-related risks, and is this disclosure boilerplate or entity specific? So the purpose of these questions was designed to have the board and management turn their mind to the issue of climate change and understand how this is or will impact their business going forward. The final thing that we want to mention about our guidance is that it talks about materiality. So we heard that materiality assessments for climate-related risks were particularly difficult to do. And as we noted earlier, in some cases, we have seen materiality being interpreted somewhat narrowly. This is because the understanding of climate change is an evolving space, and risks inherently tend to be more longer term, which makes it more difficult to assess climate risk with precision. This is an important point, as materiality is the lens to use when determining if information must be disclosed. So for purposes of continuous disclosure, as Samreen mentioned, materiality is based on the reasonable investor test, which means that information is likely material if a reasonable investor's decision to buy, sell, or hold securities would likely be influenced or changed if the information in question was omitted or misstated. The Sustainability Accounting Standards Board, also known as SASB, is a nonprofit organization founded in 2011 to develop sustainability accounting standards. And it found that 72 of 79 of their industry classifications are significantly affected in some way by climate-related risk. As a result, we felt that it was important for our guidance to set out general principles for making these materiality assessments and include specific considerations in the context of climate change. Climate-related risks will affect companies in different industries and even different companies within the same industry in different ways. What this means is that companies should consider both quantitative and qualitative factors when assessing materiality. There is no bright line test, and we caution companies from relying solely on a monetary threshold to determine materiality. Some climate-related matters may not be quantifiable at this time, but may nonetheless be material. Our guidance also noted other resources that could help with these assessments, including the SASB framework. So what exactly are climate-related risks? There are two general categories of risk. The first are physical risks, and the second are transition risks. Both can be in the short and the long term. Physical risks resulting from climate change can be event-driven or acute, or longer-term shifts, such as chronic risks in climate, which would be shifts in climate patterns. Physical risks may have financial implications for organizations, such as direct damage to assets and indirect impacts from supply chain disruption. Acute physical risks refer to those that are event-driven, including increased severity of extreme weather events, such as cyclones, hurricanes, or floods. Chronic physical risks refer to longer shifts in climate patterns, for example, sustained higher temperatures that may cause sea level rise or chronic heat waves. So transition risks arise from the transition to a lower carbon economy, which may involve reputational, market, regulatory, policy, legal, and technology-related risks. Reputational risks arise from changing internal and external stakeholder perceptions related to the way that an issuer is viewed as contributing to or hindering a transition to a low carbon economy. Market risks arise from shifts in supply and demand for certain commodities, products, and services as climate change related impacts are increasingly considered in decision making. Regulatory risks arise from increased regulation of climate change related matters. For example, increased costs of greenhouse gas or GHG emissions, enhanced disclosure requirements, or regulatory action as a result of non-compliance with existing climate change related disclosure requirements. Policy risks arise from policy actions that attempt to constrain actions that contribute to climate change, or policy actions that seek to promote adaptation to climate change, such as carbon pricing mechanisms, incentives for the adoption of lower emission sources of energy and energy efficient solutions, and the promotion of more sustainable land use practices. Legal risks arise from exposure to legal action resulting from a variety of factors, including, for example, failure to appropriately address climate change-related risks and insufficient disclosure of material risks. Finally, technology risks arise from the introduction of new technology which displaces old systems and disrupts some part of the economic system, and include the costs associated with investing in lower emission technologies and substituting products and services with lower emission alternatives. It's important to note, however, that physical and transition risks are increasingly becoming interrelated and cannot always be separated. So for example, the impact of technology, a transition risk on an issuer's direct assets, shows us the blurring of the lines. On this slide, we provide examples of the potential impacts of these climate-related risks could have on a business. So this can include damage to assets, supply chain and operational disruptions, availability and quality of water, availability of insurance and financing, shifts in customer perceptions and preferences, increased shareholder concern, restriction on licenses, and increased costs in a variety of areas, including GHG emissions, among other examples. This slide provides an illustration of the potential financial impacts of climate change-related risks, which could include valuation and impairment of assets, as well as decreases in revenue due to decreased demand. So finally, we want to close off our presentation by highlighting some key international and domestic developments that may be of interest in this area. Starting with the ISSB, by way of quick background, the ISSB was established by the IFRS Foundation to sit alongside the International Accounting Standards Board. And this was initially proposed in a consultation paper back in September 2020 on the role that the IFRS Foundation could play in relation to sustainability disclosures. In November of 2021, as part of COP26, the IFRS Foundation announced the formation of the ISSB, which was tasked to develop standards that would result in a high-quality, comprehensive global baseline of sustainability disclosures. The creation of the ISSB was followed by the publication in March 2022 of two exposure draft standards. Following this process, the ISSB published its final standards in June of last year. The standards are IFRS S1, General Requirements for Disclosure of Sustainability-Related Financial Information, and IFRS S2, Climate-Related Disclosures. Moving on to the SEC, so in March of 2022, the SEC also published proposed rule changes that would introduce climate-related disclosures for registrants. There were thousands of comment letters submitted to the SEC in response to this rule proposal. After considering the feedback on the 2022 climate proposal, on March 6th of this year, the SEC adopted rules to enhance and standardize climate-related disclosures for investors. The Canadian Sustainability Standards Board, or the CSSB, was established to work with the ISSB to support the uptake of ISSB standards in Canada, highlight key issues for the Canadian context, and facilitate interoperability between the ISSB standards and any forthcoming CSSB standards. So with that, on March 13th of 2024, the CSSB published its first proposed Canadian Sustainability Disclosure Standards, or CSDS, for public consultation. These CSDS standards are intended to align with standards developed by the ISSB, but include certain Canadian-specific modifications. Comments on those proposals are due in June of this year. So moving on to the CSA, in October of 2021, the CSA published for comment proposed disclosure requirements related to climate change under proposed National Instrument 51-107. This proposal was essentially a response to the work we had done on climate-related matters over the previous decade, which I spoke about, as well as in response to the spotlight put on by investors and other stakeholders on the need for better climate disclosures by public companies. We have issued a few market updates on the status of our work since that rule was published for comment. Most recently, on March 13th, 2024, the CSA issued a news release welcoming the launch of the consultation by the CSSB on its Canadian Sustainability Disclosure Standards 1 and 2. The news release states that once the CSSB consultation is complete and its standards are finalized, it anticipates seeking comment on a revised rule setting out climate-related disclosure requirements. The CSA also noted that it continues to monitor and assess international developments in this area, including the SEC's Climate disclosure rule approved on March 6th.
I want to take a minute to thank Jonathan, Katie, and Simreen for sharing their knowledge and expertise with us today. Before we proceed to the Q&A portion, I want to point out that we have included a slide in today's presentation which contains contact information for today's presenters, as well as the OSC general inquiries and SME inboxes. Please note that while staff are happy to answer questions, this does not replace the advice of independent third-party advisors, as we are, of course, not the attendees' advisors.